Hi guys, today we'll be discussing a corporate real estate case between AAI Ltd and ZZS Ltd. My name is Damien and I will be explaining the facts of the case and issues. Yash will be going into more detail about these issues and decision. And finally, Simranveer will explain what a proactive property manager should do in this situation and conclude this presentation. So the question of this case is whether ZZS Ltd are required to pay AAI Ltd an outstanding debt. Firstly, the director of ZZS, known as FE, has another company that was previously occupying the building. So this company went into liquidation, meaning FE and ZZS agreed to pay the outstanding debt. Now, issues arise when ZZS want to vacate this property. So they agreed to pay the other company's debt, which is part of the contract, in order to secure the tenancy. This lease expired on the 15th of April 2012, but continued occupancy on a week-by-week basis. They announced plans to vacate on the 7th of November and left mid-November, despite the 20-day notice period ending on the December 5th. And overall, they had outstanding rent and OPEX payments. In this case, many issues had arisen, one being in regard to ZZS Ltd giving a 20-day written notice to end the lease. And if so, is the tenant responsible for outstanding rent and operating expenses? Well, according to Section 210 Property Law Act 2007, if no term of lease is agreed upon, either party may terminate the lease at their discretion by giving a 20 working day notice period. Because no term of occupancy was agreed upon after the lease's expiration, Section 210 of the Act came into effect by default. Therefore, a 20 working day notice was required to be given by AAI to ZZS. Furthermore, Section 211 of the Act outlines that tenants' obligations still remain after lease expiration if they are still in possession of the property. This means that the tenant is responsible for the outstanding rent and OPEX at 7% until the end of the notice period.
ZZS Ltd also argued whether the 15% interest charge per annum was owed. They had many outstanding payments of interest owing for multiple invoices from the 7th of November 2012 to the 5th of December. In accordance with Clause 5.1 in the ADLS Deed of Lease, if the tenant, in this case ZZS Ltd, defaults in rent or any other money payable for 10 working days, ZZS Ltd is obliged to pay the default interest rate of any outstanding debt from the due date for the payments. Therefore, since 15% is the default interest rate in the ADLS Deed of Lease, ZZS Ltd is obliged to pay $286.83 of interest that is owed on the outstanding payments. Another issue was the rent and operating expenses owing at the end of the tenancy. ZZS Ltd and AAI Ltd agreed on having the rent paid on a weekly basis and 7% of outgoings being charged as operating expenses in accordance with Clause 3.1 and it being stated in the first schedule of the ADLS Deed of Lease. AAI Ltd believed that the notice period ended on the 6th of December 2012, when in fact it ended on the 5th of December, with the rent being reduced accordingly. Therefore, the court ruled that the rent and outgoings ZZS Ltd owes of $476.88 must be paid until the end of the 20 working days notice period on or before the 5th of December 2012. Furthermore, ZZS Ltd also argued whether the unpaid outgoings for months June, August, and November were owed, in which the court ruled there is no reason for ZZS Ltd not to pay the invoices unless there is a right to set those operating expenses off against other payments made. One of the main disputes was whether ZZS Ltd's coverage of JF Ltd's debt of a total of $3,500 will be able to offset their debt of $3,318.98. It was argued that AAI Ltd should have approached a liquidator to sort out the sum instead of taking money from ZZS Ltd. However, as part of the agreement, ZZS Ltd had agreed on paying off JF Ltd's debt, and it was understood that if ZZS Ltd had not paid off the debt, they wouldn't be able to take on the lease. Therefore, The judge ruled that ZZS Ltd's agreement to pay off JF Ltd's debt of $3,500 cannot offset the outstanding debt ZZS Ltd owes at the end of the lease. In light of the issues that were discussed, the court ruled that ZZS Ltd is obliged to pay AAI Ltd $3,605.81, that being $3,318.98 for the outstanding invoices, rent, and outgoings until the expiry of notice, and $286.83 being interest at 15% per annum.
A proactive property manager would have avoided these issues by making sure there was good communication between all the parties involved. This would have been achieved through a good communication system being put in place, where everyone was well informed and on the same page. Regular communication between the property manager and its tenant, ZZS Ltd, would have meant that towards the end of the lease, ZZS Ltd would have known that they are to move out before the end of the lease, or begin to renegotiate terms of the lease with AAI Ltd. A proactive property manager would have reminded the tenant that under clause 32.1, 3 months before the expiry date, a written notice could have been given to AAI Ltd if they want to renew the lease, as retaining tenants is cheaper in the long run, and this could have avoided risks related to vacancies. In addition to this regular communication, it would have allowed both the landlord and the property manager to identify the issues of non-payment of rent and operating expenses. Not only would regular communication make ZZS Ltd and AAI Ltd more comfortable with each other, but also allow them to talk through problems or issues they have. A proactive property manager would get in contact with ZZS Ltd and collect the outstanding payments, sort out any misunderstandings they have, and avoid the court case altogether. The dispute for rent and operating expenses could have also been avoided through checking the creditworthiness of ZZS Ltd, keeping on top of payments and ensuring rental payments are being collected. Rental not being collected from the first month would have made the property manager aware of risks that are arising and talk to the tenant to make sure they understand that these obligations must be met. Before the lease was signed, a guarantor could have been involved, making sure ZZS Ltd will not default from any obligations, and if they did, they could seek remedy from the guarantor. The dispute arose after many months of not receiving rental, so being on top of the rental and making sure amounts were being collected were correct by the property manager, this would have meant the dispute could have been avoided or mitigated altogether. In conclusion, the dispute arose out of a lack of involvement and communication between the parties involved. Rent and operating expenses not being received could have been dealt with earlier, but left alone for a few months had a greater impact. Constant communication between the property manager and ZZS Ltd would have meant that the property manager was aware of any financial instability and knew the tenant understood their obligations and timeframes involved. Overall, if a proactive property manager was in play, the dispute could have been avoided altogether. Thank you for listening to our presentation.